Thank you very much. Thanks, Bob, for that kind introduction. Yeah, sometimes I have to say this is the case of Gaines versus Canada, and I am the director of Canadian Studies at the University of Missouri, and I have to say this is a different Canada. It's not the same Canada. This Canada, of course, is the registrar at the University of Missouri. Well, thank you all for attending this presentation, and thanks in particular to Emily Luker back in the back, and Brian and all the folks at the Missouri State Archives that make not only this talk work well, I hope, but they make this series work as well. The Missouri State Archives is a great resource for research on Missouri history. I'm here off and on, though I haven't been here for a few months, but I'll be getting back into that pretty soon. We're lucky to have such a fine institution within the state of Missouri. Well, Bill Porter and I, my colleague in this endeavor, like many professors of political science, mentioned the Gaines case in our freshman American government classes. It's the first case, and it sets the precedent in a series of civil rights cases that leads up to Brown versus Board of Education. Because the case involves the University of Missouri, and we teach at the University of Missouri, we probably discuss it more in our own classes than in the typical classes of faculty at other universities. But nevertheless, it is a landmark case. And Bill and I became interested in learning more about Lloyd Gaines and about the background of the case. But when we were starting discussing and researching more on the book, we were surprised that there had never been a major work on Lloyd Gaines in this case that was actually completed. In addition, the circumstances around Lloyd Gaines and his disappearance simply make this a great story. And I think this story teaches us a lot about the civil rights movement and those people that were involved in it. One of the most important cases involving equal opportunity, and arguably the most important case before Brown versus Board of Education, is this Supreme Court decision of Missouri Lloyd Gaines versus Canada and the Board of Curators of the University of Missouri. It's the first time the United States Supreme Court applied federal constitutional protections of equal protection of the laws to education. It's the first step in the eventual destruction of then legal racial segregation in education. And I think the Gaines litigation could possibly have led to a decision such as Brown, ruling that separate educational facilities are inherently unequal, but it never actually was finished. There was that second step that never followed through, and I'll get back to that idea in a few moments. And as Bill and I researched the case further, we found out that a lot of the aspects of conventional wisdom were false. For instance, if you read some legal history, you read that the United States ruled that Lloyd Gaines had to be admitted to the University of Missouri Law School, and they just never showed up. And of course, that's false. Not only was it not the case of him just not showing up, he was never actually admitted to the University of Missouri. It was more complicated than that. So we wanted to find the real story behind this important constitutional case. Well, as most of you know, racial segregation occurred in much of the nation, particularly in the South and within the state of Missouri in the early 20th century. Although the 14th Amendment to the U.S. Constitution, which was ratified after the Civil War, guarantees equal protection of the laws to all citizens, the United States Supreme Court, in the 1896 case of Plessy versus Ferguson that Bob alluded to, upheld racial segregation through what will become known as the separate but equal doctrine. And this case established the legal doctrine with the idea that segregation could be legally protected within a state just as long as segregated facilities for blacks were substantially the same quality as for whites. But of course, those segregated facilities were never actually equal. For instance, within the state of Missouri, separate educational facilities were provided for white and black students, and segregated facilities went all the way from primary education all the way up to institutions of higher education. Well, founded in 1909, one organization that was dedicated to dealing with this was the NAACP. The executive director of the NAACP, if we can, the next slide there, Brian, thank you, is the fellow there on the far left, Walter White. He embarked on a number of efforts during his directorship to improve the status of African Americans, including congressional lobbying on behalf of an anti-lynching law. So this is Walter White right here on this side, and this is Charles Hamilton Houston, someone that we're going to hear a lot about over the next few minutes, who led the legal efforts. In addition to White and to Houston, the next person on the slide is Roy Wilkins. On the next slide, please. That's Roy Wilkins. He led the public relations activity on behalf of the NAACP. He was the editor of The Crisis, the in-house magazine of the organization, and he coordinated information for numerous black newspapers across the United States. The black press was an important and vocal supporter of the NAACP legal activity. Although he's raised in Minnesota, Wilkins was actually born in St. Louis, and he worked for some time at The Call, the influential black newspaper in Kansas City. It was founded by Chester Franklin. In fact, it goes from The Call to the NAACP. In the 1920s, the NAACP received a grant from the Garland Fund, also known as the American Fund for Public Service, allowing the organization to pursue a legal agenda to promote civil rights. And one of its early strategists was a white Northeastern lawyer named Nathan Margold. And Margold prepared a comprehensive plan for overcoming the doctrine of separate but equal and eliminating segregation in the United States. And you can see there it's a huge, thick report with lots of detailed legal plans. The Margold report offered plans for overcoming segregation in many aspects of American life, including access to public facilities and primary and secondary education. While the report mentions higher education, it was not a priority for Margold. Well, the NAACP suffered almost perpetually from financial difficulties, and it was clear when the Margold report was published that it would be difficult to pursue such a wide-ranging legal agenda. So in the 1930s, a brilliant legal mind took over as leader of the NAACP's litigation efforts, Charles Hamilton Houston, who will later become known as the man who killed Jim Crow. Houston was a graduate of Harvard Law School, where he served as the first black member of the Law Review, long before our recent president ever got there. He was the very first black member of the Harvard Law Review. He went on to be both a professor and a dean at the Howard University Law School in Washington, D.C. Houston was from D.C. also. Houston's ideas were similar to Margold's, but Houston was particularly interested in pursuing desegregation of higher education. There were many reasons for this. Thank you. There were many reasons for this. The belief that the climate would be more liberal and more accepting in the world of higher education. You're not talking about small children, you're talking about adults. Maybe we can deal with that a little bit better. There is also Houston's belief that the general population would simply be less interested in higher education, and therefore less threatened by desegregation of higher education. And Houston also had the strong belief that higher education would lead to better paying jobs for African Americans, which would in turn lead to more opportunities for black Americans. Within the state of Missouri, all state public universities were for white students only, with the exception of the poorly funded Lincoln University in Jefferson City, which was open for black students only. This is an early picture from the 1930s of what Lincoln looked like at that time. In addition to that, black Missourians had no opportunities for graduate and professional education within the state of Missouri, and in fact, within most of the southern border states. None. No graduate and professional opportunities at all. Missouri, I should note, was somewhat an innovator in the idea of racial segregation, and often good intentions lead to the perpetuation of racial segregation. This is the first black member of the Missouri General Assembly, Walthall Moore. He actually proposes the legislation that makes what was formerly Lincoln Institute, a private organization, come into as a public university within the state of Missouri. Lincoln Institute was established with contributions from the 62nd and 65th Colored Infantry from the Civil War as a means to provide education for black college students. So after Moore's bill passed, the Lincoln University Act, Missouri takes over the institute, renames it Lincoln University, and made it the state's only college for black students. Those of you may know that Harris Stowe in St. Louis is also a historically black college. However, Stowe at this time, Harris and Stowe were two components, but they were both St. Louis colleges. They were not state universities. They were city colleges to train teachers. So it doesn't come into play at this time. So the legislation that's sponsored by Representative Moore the first first black legislature within the state of Missouri, also offers black students tuition scholarships to attend schools for out-of-state programs if they're offered in white-only institutions and otherwise unavailable for blacks. So it's this out-of-state tuition program which provides black citizens with an opportunity for graduate professional education, but it also means that state colleges will remain exclusively white. Of course, the state of Missouri never adequately funded or administered this out-of-state tuition program. Well, Charles Houston argues that the out-of-state tuition scholarship made a stronger legal argument that separate but equal was violated within the states. Because with this out-of-state scholarship program, they operated as not separate but equal, but separate but nothing for blacks. The litigation, according to Houston, would be less complicated than comparing quality of black and white institutions within the same state. So an early effort that's made by the NAACP is led by Charles Houston, who is sitting over here to the far right there. That's Houston. It's made on behalf of Donald Gaines Murray, a Maryland resident. This is filed in the state of Maryland, and the Gaines is completely coincidental. There's no relationship between the two. And then this fellow that's standing here is the person that Charles Houston hired as his lieutenant, Thurgood Marshall. And Marshall was actually key in arguing the case of Murray versus Peterson, which was the case in Maryland. And the case that involved the University of Maryland and Donald Gaines Murray was actually decided successfully. Maryland had the same sort of system where students were offered financial assistance to send out of state for law school and so forth. So the NAACP is successful, winning a decision at both the state trial and at the equivalent of the Maryland Supreme Court, which orders Murray's admission to the law school. So this is an important victory, but at the same time, Houston and the others have to understand it's tempered because it only applies to Maryland. It's not a federal decision. It only applies within the state of Maryland. And since they won the case in Maryland, there's no appeal to the United States Supreme Court because they won. It's good for Murray, but a decision in Murray's favor could have established a precedent for the whole nation, but it just doesn't come. So Houston and the others in the NAACP knew that the Maryland decision was not enough, so they sought another case that could take them to the U.S. Supreme Court. One place they looked was Missouri. Missouri was a border state. It had large, educated black communities in St. Louis and Kansas City. There was only one state institution which black Missourians could attend. That was the relatively small Lincoln University in Jefferson City. And in Missouri, Houston found an ally in St. Louis, someone that he knew well, attorney Sidney Redmond, who is the fellow on the far right over here. That's Sidney Redmond. Redmond was a black lawyer who, like Houston, attended Harvard Law School. He, like Houston, was the son of a prominent attorney. He was actually from Mississippi originally. Both Houston and Redmond were workaholics. They were devoted to civil rights litigation, and they were both marvelous attorneys who wanted to get every single thing right. Everything had to be exactly right. They had known each other from their family's association earlier. Redmond was also a leader of the NAACP in the St. Louis area. He was a key organizer of the Mound City Bar Association. At this time, the Bar Association in St. Louis was white only, so he founded an alternative organization. He also helps organize the National Bar Association, which at this time is the national organization for black attorneys throughout the country. Redmond's law partner, Henry Espy, who also led the St. Louis NAACP, worked with Redmond in the efforts to investigate and later litigate against the University of Missouri. Now, this is a picture when they're much older, as you can tell. That's Redmond on the right, and there's Henry Espy on the left. Espy was originally from Florida. Redmond was originally from Mississippi. So Redmond took over the job of investigating the University of Missouri and began to find clients to file suit against the University of Missouri. And he was careful in all this process to try to avoid the perception that he was actually soliciting clients. This was something that the University of Missouri was accused, or the state of Missouri, I should say, was accusing him of doing. And according to Redmond, the attorneys for the university and for the state establishment were always trying to get him disbarred. That was actually the reason why he left Mississippi. His father had stayed, but Sidney Redmond Jr. Left Mississippi under the understanding as if you stay, you'll be disbarred and your father will be jailed, but if you leave, we'll work things out. So he left first for Illinois and then eventually landed in the St. Louis area. Well, eventually they meet, and by the way, before we get going, before we change slides here, this is the actual agreement that Charles Houston and Sidney Redmond agreed, because it's the national NAACP and the local attorneys. One of the things that Bill and I try to point out in the book is we often think of Charles Houston and Thurgood Marshall as being these great leaders, and they were. I don't want to detract from that at all. But at the same time, they had to have people that were working with them in the local communities. Houston and Marshall knew nothing about Missouri law, but the case was going to be tried in Missouri courts, so they had to get Missouri lawyers, black Missouri lawyers, to work with them, and that can't be discounted. And you can't really read it very well over here on the right. I don't think anyway. Can you read that? I think so. It's a letter back from Sidney Redmond when he agrees with this, and in the text there in that paragraph, he says that first it's going to be difficult to find a plaintiff for this case. I want you to know, Houston, that it's going to be hard to find somebody that's going to carry this case through. And the second thing he says is, by the way, you should also know there have been lynchings in Columbia. And to those of you from this region, you may know the lynching of Jim Scott, who was a University of Missouri employee. He was falsely accused of attempted rape. He was taken out from the Boone County Jail and lynched. That occurred, if I remember correctly, in 1923, which is just about 12 to 15 years before this occurred. So for all of the people that are involved in this who live in the area, they are well aware that lynching is a possibility within Columbia, that it happened recently. Well, who we found next is Lloyd Gaines. He was a graduate of Vashon High School in St. Louis and a graduate of Lincoln University. In fact, he graduated from Lincoln with honors in 1935. And I always have to say that we actually found his transcript, his grade transcript. And I think one of the things that Bill and I find humorous is he was an outstanding student, right? The best in his class. He had a C average. And the grade inflation today is just so different than what it was then. But nevertheless, he was an honors student. And he was the senior class president. He wanted to go to law school, and along with several other prospective clients, he sought the help of the NAACP in making a case to attend the University of Missouri Law School. He sought out Redmond in St. Louis and had a meeting with the attorney. And I should note, for some of the people in the audience here, that it was his mentors at Lincoln who had encouraged him to continue this. He had expressed some interest in the law school. In fact, a lot of what Lloyd Gaines a lot of what drew his interest is that the National NAACP convention was held in St. Louis, and one of the big meetings was actually held in the Vashon High School auditorium, which is now Harris Stowe, but at the time it was the high school. And he was really, he was really pumped up. It's like yes, we can do these kind of things. And so that, along with the encouragement of his Lincoln University faculty, led him to meet with Sidney Redmond. So Lloyd Gaines requested a catalog and an application from the University of Missouri registrar, who was Silas Woodson Canada, or as he's commonly known, Cy Canada. Well, here's a picture of Lloyd Gaines with his fellow Lincoln students. This is Lloyd Gaines here in the light suit here. And that's his fraternity Alpha Phi Alpha. So he requests a catalog and an application from the registrar. And actually, Bill and I also thought it was funny, as you go back in time, the application process to go to the law school was so different back then. It involved all these steps that you had to go through. It wasn't just like fill an online form and sign the bottom, nothing like that. So Gaines was a strong candidate academically, and if he were rejected by the University of Missouri, it might be argued that he was rejected on the account of his ethnicity and nothing else. So we see what's happened, sort of what Redmond says. So Gaines' application was received by the University of Missouri. So far, so good. Positive reception. Cy Canada writes back and says, well, what we need now is, at this stage, we need you to send your transcripts. went to Lincoln University, and I should say at this time, one of the things the depth of difficulties in dealing with segregation were deep. The presidents of the black colleges at this time actually got a lot of pressure from the establishment figures in the various states never to send the transcripts. And the president at this time, Charles Florence, Sidney Redmond wrote to Charles Houston being very concerned that Florence might just never send the transcripts. And if you never send the transcripts, then Gaines can never be admitted. But Florence, to his credit, actually told his staff person, yes, send the transcripts. And although it may be for unrelated reasons, Florence is also fired within the next few months. We found no link between the two activities, but nevertheless, he wasn't there for much longer. So, Gaines's transcripts are sent to the university, and of course, Psi Canada receives them, and they are from Lincoln University. And so the next thing that Psi Canada does is he takes it down the hallway to the new president of the university, who is Frederick Middlebush. Frederick Middlebush is a professor of political science who had just got the job as university president. And as a political scientist, I am somewhat ashamed that Middlebush had the opportunity to do something positive, but he did not. He informs Canada to do what was the understanding at that time which was do nothing. Just don't respond. Go ahead and go to the next slide, please. Now, Middlebush was going to be there. In fact, he will be there through far beyond the end of the resolution of the Gaines case and all the litigation that follows. That's Middlebush right there in the center. He becomes not just the acting president, but the full president of the university. As you can see here from all the naval officers surrounding him and so forth, he was very influential. And I don't know if you can see, actually, Psi Canada is right back there in the background there, standing back behind, but he was there as part of the university administration. And so let's actually go to the next step. And so initially, the University of Missouri just decides that they do not want to make any kind of decision at all. And so at first, Gaines has to formally ask for additional counsel from the NAACP, and through Sidney Redmond, he makes a formal request to Charles Houston that the national office of the NAACP come to his effort and serve as his legal counsel. So a suit is filed, and the Gaines case asks the Boone County Circuit Court to compel the university to admit Gaines. And there are actually sort of two stages. There's first one in January of 36. We can go on, thank you. Then there is a second stage that actually follows in March of 36. And that's when a decision is made by the University of Missouri Board of Curators. Now, this is the first set of curators. This is actually the board at the time that Gaines applies. And the president of the university, as you see, he's kind of frail over there, is Walter Williams, who establishes the University of Missouri Journalism School and so forth. If we can go to the next slide, this is the board as it was comprised at the time they made the decision about Lloyd Gaines' case. So there is Frederick Middlebush again, and there the rest of them are the head of the Board of Curators, and there is Frank McDavid, who's the head, the leader of the board at that time. So in March of 1936, the Board of Curators votes, this is the board, not Psi Canada, not Frederick Middlebush. The Board of Curators votes to deny Lloyd Gaines' admission. The Board of Curators passes a very specific motion. It says, be it resolved that the application of said Lloyd L. Gaines be and is hereby rejected and denied, and the registrar and the Committee on Entrance be instructed accordingly. The NAACP attorneys are actually delighted at this stage. It identifies Gaines by name. And the resolution also gives a clear reason for his rejection, the rejection of his application, that he is, and I'm using a direct quote, a colored student who should not be admitted to the University of Missouri. And so this allows Redmond and Houston to drop the first case and to file a second case. And in this petition, it claims only that Gaines was a qualified Missouri taxpayer and he met the qualifications for admission, and so the registrar, Silas Woodson Canada, should be compelled to admit him to the university. And to Redmond, in a letter, Houston emphasizes The issue is now squarely on the race question, but in drafting the petition, do so without reference to color and make them plead color in the answer. This will give us the opportunity to challenge inequality and raise the whole question of equal provisions. Now, Thurgood Marshall actually is not very deeply involved in the Gaines case. He's back in Washington, D.C. Houston does contact his young lieutenant from time to time asking about this, and one of the things that Thurgood Marshall remembers is they just simply could not believe how could they have made such a blunder, because they thought, the NAACP attorneys thought, they were going to be spending all their money arguing about whether or not the case was actually about race, and the Board of Curators just out and out said, no, this is about race. And it's like, that saves all the arguments, all the critical arguments that we have. So the case goes on to trial in the Boone County Circuit Courtroom of Judge Walter Dinwiddie in July of 1936. Oh, yeah, okay, that's fine. It goes to a gallery filled with a lot of people. Houston, of course, is representing Lloyd Gaines along with Sidney Redmond. And at the trial, the prominent Kansas City attorney William Hodgson is the university's lead counsel. That's him shown in this slide here. I don't have very many pictures of Hodgson. Hodgson was really sort of the attorney's attorney. He had argued a number of cases before the Supreme Court before. He dealt with really big cases involving life insurance and so forth. So he was really a prominent attorney within the state. That's who was going to represent the University of Missouri. And he had a number of other lieutenants working with him too. There's a whole cadre of lawyers working for the university. So the case goes to trial in the Boone County courtroom in July of 1936. It's in a gallery full of whites, blacks, university students, farmers coming in to get their checks. Remember, this is in the Great Depression at this point. This is all sorts of people from Columbia are there. And in fact, the courtroom is packed. I mean, it is completely packed with people sitting up the aisles. Every seat is taken. Every aisle space is taken. And Houston later expresses a lot of surprise because the proceedings, this is about racial segregation, the proceedings themselves were not segregated. Blacks and whites were sort of scattered throughout the audience. He was also surprised that the water fountains in the restrooms were used by both blacks and whites. And he describes how some of the farmers who were coming to pick up their checks kind of looked at them funny, but nobody even said anything about all this. He expected much worse. Well, at the trial, Kansas City Attorney William Hodgson, who we just saw there, the university lead counsel, argued that Lincoln University was not inferior to the University of Missouri. In fact, it was of excellent quality, equal or better than the University of Missouri. And on the stand, the dean of the law school, who's over here on the right, William Masterson, says sort of the same thing and argues, and when you read the transcripts, I mean, it's like a comedy that you're reading. He argues that there's no particular advantage to going to law school at the University of Missouri. It's not particularly good. And Houston says, well, what about people who want to practice law in Missouri? It's the only public university in the state. You know, what if you want to practice law in Missouri? Don't you need to go there? No, not really. No, actually, Missouri residents, they're just as good going to Illinois or Kansas or some other law school, which is not that good. Of course, Houston, it's just a comedy. Houston does appreciate that Psi Canada at least tells the truth. He just says, yes, these other folks can be admitted, no, there are no blacks admitted, and so forth. Judge Dinwiddie actually rules against Gaines, and actually the original petitions up here for the circuit court case are up here with the signatures of Charles Houston and Sidney Redmond, if you want to come and look at them after the talk, too. So Judge Dinwiddie rules against Gaines, and he does so without any kind of statement. The case goes against them. It's for the University of Missouri, and the case is appealed to the Missouri Supreme Court. And of course, things don't go well for the NAACP and Gaines in Jefferson City either. I'm not going to talk about that because it's kind of a detailed thing, and it's not really directly relevant to our story. So just go on to another slide here. We see that both the white press and the black press are talking about this. And to Charles Houston, the loss at the Missouri Supreme Court was not particularly disappointing because it offered him the opportunity that he most wanted. That is, he wanted an appeal to the federal courts. He wants a decision that applies nationally, not just in Missouri. So the United States Supreme Court was always the planned venue for an application of the Equal Protection Clause of the 14th Amendment. So Houston and Redmond prepared to appeal to the United States Supreme Court, but Walter White, the executive director of the NAACP, and others were pessimistic, and they did not think that the United States Supreme Court would hear the case. Houston was confident they would hear it, and ultimately he was completely correct. But the NAACP defense had another big problem. This was the Depression, 1938. They got their money back in the early 20s, 1921 if I recall. That money is gone. There is no money left from the Garland Fund. So they are completely out of money. All this multi-pronged legal strategy that they attempted, even though Houston is trying to limit it to higher education, not to the Markle Court's original goals, it is all gone. And Walter White and Roy Wilkins emphasized other priorities. In particular, they wanted to emphasize congressional passage of anti-lynching legislation. And they are not going to succeed at that, by the way, but that's what they wanted to do. So White, I'm sorry to say, really made Houston grovel. He had to go back and find other white attorneys who said it's worthy of appealing to the United States Supreme Court, including Peter Markle. He had to go back and get a statement from Peter Markle saying, yes, the Supreme Court might actually even hear the case. White and the others didn't even think they would grant a writ for the case, let alone would they actually decide in their favor. However, Houston was confident, and he succeeds. The Supreme Court of the United States, under Chief Justice Charles F. Hughes, issues a writ of certiorari, and it seems clear in the oral arguments to the case before the Supreme Court that several of the justices are actually sympathetic to Lloyd Gaines and the NAACP's arguments. The Supreme Court rules very quickly. Oral arguments took place in November of 1938, and the court issues this decision on December the 12th. That's fast for the court. And by a wide margin of 6-2, the Supreme Court rules in Gaines's favor. And that's big news in the press, too, as you go forward. And we also have an example from the white press. St. Louis Argus is, at this time, the biggest black newspaper in St. Louis. Now it's the American, which was there at the time, but they're sort of switched places. This is more, positive news from the Kansas City Call. The Call in Kansas City, and I think we could see Charles F. Hughes there. So Charles F. Hughes, the Chief Justice, writes the majority opinion, and he articulates the clear violation of equality or equal protection within the state. And let me read you just a little bit of the decision. By the operation of the laws of Missouri, a privilege has been created for white law students which is denied to Negroes by reason of their race. The white resident is offered legal education within the state. The Negro resident, having the same qualifications, is refused it there and must go outside the state to obtain it. That is a denial of the equality of the legal right to the enjoyment of a privilege which the state has set up. And the provision for the payment of tuition fees in another state does not remove that discrimination. So the court in its decision makes the first clear application of the 14th Amendment's Equal Protection Clause to the states. Moreover, the court stressed that equal protection is the right of an individual. The court's emphasis was now and continued to be on equality of opportunity. The court did not demand that Gaines be admitted to MU. Gaines was either entitled to admission to a law school at MU or at another substantially equal alternative for black students within the state. Now, there was none, of course, but that's not what the Supreme Court is making a decision. So they're going to send the case back to Missouri to resolve it. Now, I should note also that there is a dissent to the case of two justices. Pierce Butler joins with James McReynolds, and he wrote a scathing dissent of how the decision is just going to destroy the relationship in many states. And to quote McReynolds' decisions, it will damnify both races. Well, meanwhile, it's unclear what Lloyd Gaines is going to do. And here is the court. And one thing I should also add is one of the reasons why they did not, the NAACP was very hesitant to bring this case. There were still two members of the Four Horsemen against FDR. In addition, another justice had recently been confirmed, Hugo Black, which a lot of the literature from the NAACP referred to him as the justice of the KKK because he had involved, or at least got the endorsement of the KKK in Alabama. So they just thought that black was going to be a negative vote and swing other votes. Houston didn't really write about black in particular, but he was confident that the Supreme Court was ready to make a change, and he was right. So meanwhile, what does Lloyd Gaines do? The Supreme Court decision was 3.5 years after, actually, let's skip the next two, just because I'm running out of time a little bit here. The Supreme Court decision was 3.5 years after he first applies for admission to Missouri Law School, and he seems no closer to a law degree now than he did at the time he applied. Being a civil rights hero does not pay the bills. Gaines worked at odd jobs in St. Louis. He did things like pumping gas. In fact, he's very dissatisfied because he thinks he's being used by the cab company who owns the filling station. He thinks he's being used to rip off consumers. His fame and popularity is being used to rip people off. So he's very dissatisfied with the jobs he has available in St. Louis. He finagles an anonymous loan through the NAACP, which is really against protocol. You don't borrow money from your lawyers, right? But he somehow manages. I mean, they need him, right? The NAACP needs him. He finagles a loan to attend graduate school in economics at the University of Missouri. He never actually finishes the degree. He does go there for a full year in a master's program in economics. He was a recognized figure in the black community. In fact, another civil rights hero, I guess the state of Texas, at the University of Texas, Heman Sweat, actually knew him. They were both at Michigan. They lived right around the corner from one another. Sweat did not particularly like Gaines, by the way. He thought he was very uppity, very vain, and so forth. He didn't like him at all. But he is a recognized figure, and so following the Supreme Court decision, Gaines comes back to Missouri. He gives big speeches to very large audiences in St. Louis and in Kansas City and other communities. And after his final Missouri visit in Kansas City, he speaks to over 1,000 people at the Centennial Methodist Church on Woodland Avenue. After that, he boards a train for Chicago at Union Station with the hope of finding some employment in Chicago. And in March of 1939, about 3 months after the United States Supreme Court decision, Gaines mails a long letter to his mother on March the 5th. And that's what you see the first page of here. And in the letter to his mother, Gaines writes that he traveled to Chicago hoping to find it possible to make my own way. Gaines goes on to explain that his conscience prevents him from working in St. Louis, but he has difficulty finding another job. And he writes to his mother about his role in a landmark court decision. So please bear with me and I'll read part of this. This is a wonderful letter. As for my publicity relative to the university case, I have found that my race still likes to applaud, shake hands, pat me on the back, and say how great and noble is the idea, how historical and socially important the case. And there it ends. Off and out of the confines of the publicity columns, I am just a man. Not one who has fought and sacrificed to make the case possible, one who is still fighting and sacrificing, almost the supreme sacrifice, to see that it is a complete and lasting success for 13 million Negroes. No, just another man. Sometimes I wish I were just a plain, ordinary man whose name no one recognized. And then Gaines closes the letter to his mother this way. Should I forget to write for a time, don't worry about it. I can look after myself okay. As ever, Lloyd. Meanwhile, the state of Missouri prepares its own response to the U.S. Supreme Court decision. Rather than integrating the student body at the University of Missouri, the state sought an alternative that might fit the conditions set by the United States Supreme Court. Through the introduction and passage of the Taylor Bill from John Taylor, a representative from Keithsville, that's him here, the state gave Lincoln University the authority to create a new graduate and professional program and to do this on demand. Whenever there was a demand, Lincoln University had the authority to create a new program. Thus, a new black-only law school could be organized as an extension of Lincoln University immediately. The Taylor Bill was signed into law in May of '39. This this is working fast on the part of the legislature, right? The decision is handed down in December of 38. By May of 39, we have a bill to set up a new law school. And expects the Lincoln Board of Curators to have the new black law school up and running in time for Gaines to enroll in the next semester, starting in September. So it is fast. Sometimes the legislature and the bureaucracy move quickly. Well, there's no time to construct a new building or to find sufficient room in Jefferson City on the campus there. So the Lincoln Law School took over a large vacant building, the Poro College building in St. Louis. The Poro College was the home of a beauty products empire from Annie Malone, an entrepreneur, who moved her business to Chicago from a nasty divorce, as I understand it. Coincidentally, that's where Gaines is too. It's just, once again, coincidence. And so a new library is acquired from donations, and a new black faculty is hired. And the dean of the Lincoln Law School, much to Charles Houston's disgust, was William Taylor, who was his replacement as dean at the Howard University Law School. So he feels betrayed by the person who followed him at Howard. And Houston was passionate and brilliant, but in his voluminous correspondence, this is the only time that I read Houston and he lost it, and that is when he describes William Taylor and taking over the Lincoln Law School. Well, the new Lincoln faculty were recent graduates of the Howard Law School, and the state was clearly trying to put Houston and the NAACP in a difficult position. We're hiring people from Howard. What are you saying that it's not going to be competent? The Missouri Supreme Court remanded the case back to the circuit court with expectations, and it was assumed that the circuit court would rule that Lloyd Gaines could attend the equal Lincoln Law School in St. Louis. Houston and Redmond responded by organizing a new case that the hastily created Lincoln Law School was not the equivalent of the University of Missouri. It did not have equal funding, equal staffing, equal resources, and so forth. And just as a reminder, the case that would ultimately come, Brown versus Board of Education, also involved two Supreme Court decisions. The first, Brown decided that segregation was inherently unequal and violated the 14th Amendment. But the second case demanded enforcement of the first with all deliberate speed. So even back in 1939, Houston is already seeing that this is what's going to be necessary in the case. So we see the NAACP legal attorneys engaging in this strategy at this time. Now, the black community in St. Louis was divided about this development. On the one hand, the creation of Lincoln Law was the maintenance of racial segregation. On the other hand, Lincoln Law provided an inexpensive opportunity for black Missourians to obtain a legal education. And you can see that this is Julian Rogers. He does not graduate, but if you go to the next slide here, and that's actually where they're lining up outside the School of Law. So one more slide here. And I guess before I get to that, there was a picket line organized by the Colored Clerks Circle in St. Louis, and that picket line continued for several months. And the NAACP leadership in St. Louis was very divided on how to respond to this. I mean, it's a good thing and a bad thing. It's like the creation of Lincoln University in the beginning. It's a good thing in some aspects, it's a bad thing in the other aspects. So there's a lot of division. But on behalf of Gaines, the attorneys entered into this litigation. Now, this is actually Sidney Redmond, which is right there. This is Joseph Mitchell, the publisher of the Argus. There's Henry Espy there. This is David Grant, who's going to take over the local NAACP. And this is, and now I've forgotten his name, Freddie something. He's the head of the Colored Clerks Circle. They had successfully lobbied against stores like Walgreens and other stores to hire black employees. If we're going to have black customers, there should be the opportunity for black employees. So they have been successful in previous picketing in the area. So the second phase of litigation then starts, and this is the slide I meant to mention earlier, is it's easy to dismiss Lincoln Law School, but there were a lot of good black attorneys, including Margaret Bush Wilson, who would later come on to be a prominent member of the NAACP. I think she left the executive board for something like 5 terms in office or something. It did lead to some good opportunities for black residents in St. Louis and the area. So we start with the second phase of litigation on behalf of Lloyd Gaines. And so Houston and Redmond and Espy take depositions from William Taylor and the other members of the Lincoln Law faculty in St. Louis in October of '39. And after the end of the taking of the depositions, Hogsett and the university attorneys come up to them and they say, you know, we've got a desire, we also want to depose Lloyd Gaines again, because as we understand it, he doesn't live in the state. If he doesn't live in the state, he doesn't have standing to sue, so we would like to depose him. We want to know whether he's truly a Missouri resident and whether he really wants to go to law school at NU. And these are questions that, you know, we should reasonably ask. Where is he? Well, now over 4 years have passed since the original application, and Houston and Redmond have to admit that they no longer know where Lloyd Gaines is. Remember that letter from Lloyd Gaines that I read earlier back in March of 1939? Just a few days after writing that letter, Gaines was rooming temporarily in a fraternity house in Chicago. On a rainy mid-March day in Chicago, Lloyd Gaines steps up, tells the housekeeper he's going to buy some stamps, and that's it. No one has a confirmed sighting of Lloyd Gaines ever again. The crucial litigant in the first civil rights case, Lloyd Gaines, disappears. Redmond and the other attorneys make every effort to locate Gaines by contacting all the people that knew him. They contacted black leaders, papers in the black press, asked questions such as, Gaines is still missing, where is the plaintiff? They asked. This was all across the United States. Notice this is as late as 1941. In fact, it continues into the 50s. The black press occasionally pushes some on there. We discuss this more in the book, but the short version is that Lloyd Gaines simply disappeared without a trace. So on New Year's in 1940, Houston and Redmond finally have to admit to the Boone County clerk that they cannot locate their client, and the Gaines case is dismissed in Boone County Court. Now, of course, that's not the end of legal efforts promoting desegregation. Houston and Redmond pick up another case in Missouri of Lucille Bluford, who's a journalist at the Call in Kansas City, and that's the training ground for Roy Wilkins and so forth. And Houston actually thought the case for Bluford was better and stronger than it was for Gaines, and she was a better witness on the stand and so forth. And this will definitely demonstrated determinism beyond any of the other plaintiffs, but that litigation was never successful. Other NAACP cases would reach the Supreme Court, including those involving Sipuel, McLaurin, and both of those in Oklahoma, Heman Sweat, I mentioned in Texas. However, the University of Missouri remains closed to black students. It's not until 1950 when Sidney Redmond and Henry Espy represent three other litigants, Gus Ridgel, Elmer Bell Jr., and George Everett Horn. And there is Ridgel right there. And that is the first time that MU admits black students, 1950. This all started in 1935. William Hogsett is still working as the legal counsel for the university, and he finally asked for a declaratory judgment in the Cole County Circuit Court that Ridgel and the other black students would be admitted to the university. Now, this is a picture of Ridgel much later in life. That's not when he was first admitted. And the other two went to Rollo, which at this time was part of the university. The Gaines case touches many lives and continues to do so in recent events throughout the country, and even at the University of Missouri, there are still echoes from the Gaines case that continue to reverberate. Thank you.